Article 1410. The action or defense for the declaration of the inexistence of a contract does not prescribe. The line does not prescribe means that there is no time limit as regards for the filing of the petition for the declaration of its nullity. Article 1410 means that any of the said contract can be denied by the other parties because it is not in the legal way of processing the contract. For example, Alaska sells Bourbon the Pagsanham Falls and Bourbon gives Alaska the money. Of course, this contract is null and void. But suppose Alaska refuses to return to Bourbon the money, stating that there is nothing wrong with the contract. What should Alaska do? Bourbon should file an action in court to declare the inexistence of the contract. This right of Bourbon to bring the action does not prescribe. The defect in this kind of contract cannot be cured by prescription or by ratification. The defect in this kind of contract cannot be cured by prescription or by ratification means that this contract did not came from legal way, so it is said that without legal prescription, the contract cannot be cured nor cannot be void. Article 1411. When the nullity proceeds from the illegality of the cause or object of the contract, and the act constitutes a criminal offense, both parties being in pari delicto, they shall have no action against each other, and both shall be prosecuted. Moreover, the provisions of the penal code relative to the disposal of effects or instrument of a crime shall be applicable to the things or the price of the contract. In continuation, this rule shall be applicable when only one of the parties is guilty, but the innocent one may claim what he has given and shall not be bound to comply with his promise. Two situations of which Article 1411 applies: pari delicto and its meaning, is to which both parties are guilty and neither will be able to claim action against each other as both placed and made erroneous actions in the contract and will be prosecuted instead. And delicto and its meaning is to which only one party is guilty, or there is a person who is less guilty. The innocent or less guilty party is able to collect returns on what she has complied beforehand and is not bound to complete the arrangement or contract. Remember that the pari delicto is both parties are guilty and in delicto says that only one party is guilty. Example: A sold an illegally modified Lenovo laptop to B amounting to 20,000. B only paid 15,000 and A delivered merely the laptop without the installation of operating system. In this case, the parties have no rights of action against each other. The law will leave them to where it finds them. Article 1412. If the act in which the unlawful or forbidden cause consists does not constitute a criminal offense, the following rules shall be observed. 1. When the fault is on the part of both contracting parties, neither may recover what he has given by virtue of the contract or demand the performance of others' undertaking. 2. Is when only of the contracting parties is at fault, he cannot recover what he has given by reason of the contract, or asked for the fulfillment of what has been promised him. The other, who is not fault, may demand the return of what he has given without any obligation to comply with his promise. Article 1412 states that if the contracting parties are both at fault, neither of the parties may demand performance or recover what they have given by the virtue of the contract in case one of the parties are at fault. The opposing party may recover what he or she has given is not compelled to fulfill the promise stated to the contract. As for the party having fault, he or she can neither demand performance nor recover what he or she has given. Example: A minor, agreed to sign a promissory note from B, a store owner, amounting 10,000 pesos for 500. In this case, Empire Directo is not applicable. B cannot recover 500 pesos he gave A, but A, on the other hand, could not be compelled to comply with the obligation to pay 10,000 pesos arising in the note. When the parties are both in pari delicto and the cause of contract is unlawful or forbidden but no criminal offense. Example: Bella agreed to live as the common law wife of Kent consideration of the promise on the part of Kent to donate a land to Bella. In this case, the promise of Kent has for its consideration an immoral act which does not constitute a crime. Hence, there can be no recovery by one against the others where they cannot ask the fulfillment of others' promise. Article 1412 provides the rule to be followed when the nullity proceeds from the illegality of the cost object and the contract does not constitute to the criminal offense. Where both parties are in pari delicto, they cannot recover what they had given by virtue of the contract, neither can demand the performance of one.